Welcome to day 2 of the IFCLA International Conference online and in person in Barcelona. I'm really welcome and pleased to have you here at the first presentation of day 2 on AI and ethics with our prestigious speakers, whom I'd like to introduce right now. Our first speaker today will be Toby Walsh. He is the ARC Laureate Fellow and Scientia Professor of AI at the University of New South Wales in Sydney, Australia. He's part of a couple of other initiatives, including Data 61, and he's an adjunct professor at Queen's University of Technology, also in Australia. He's a strong advocate for limits to ensure AI is used to improve our lives, having spoken to the UN and various heads of states, parliamentary bodies, and to many other bodies on this topic. He's a fellow of the Australian Academy of Science, and he's authored 2 books on AI for a general audience. The most recent entitled 2062, The World That AI Made. I'd also like to introduce our second speaker today. That is Mark Penner, and he is a partner of Fasken in Toronto, the law firm Fasken in Toronto, and he's a patent and trademark attorney with much experience in all aspects of acquisition, protection and enforcement and strategic use of a wide range of intellectual property assets in Canada and around the world, obviously focusing on AI, and we'll be hearing from him today about the intellectual property rights in AI. He's acted for a range of clients, from individual investors, startups and other early stage companies to large multinational companies. And we're very pleased to have him with us today as well. And then thirdly, I'd like to introduce our third speaker today, Eduardo Lopez Roman. He's the lead for digital transformation at the digital transformation committee at ICAB. Thank you very much. And ICAB, thank you very much for hosting this conference yet again and allowing your speakers such as Eduardo to come be with us. He's a lawyer and consultant on digital law and compliance with over 15 years of experience on data protection, the legalization of information society services, digital economy, and also cybersecurity. So thank you everyone for being with us today. And it is on that note that I'd like to hand over the proverbial digital mic to Toby Walsh from Sydney. And thank you for being here today. Over to you for our first talk.
Thank you, Patricia. So good morning, everyone. I'm speaking to you from the future, literally from the future, because I'm here in Sydney, Australia, and it's already Friday afternoon here in Sydney. So as is the custom, a very great custom, a very nice custom we have here in Australia, I would like to begin by acknowledging the traditional owners of the land upon which I am sitting, the Gadigal people of the Eora Nation, and extend my respects to their elders past, present and emerging, and extend those respects to the Indigenous owners of the lands upon which all of you may be. So I want to try and set the scene here in some ways by talking about where artificial intelligence is, why it is that you're hearing so much about AI these days, and identify some of the ethical and legal problems that the technology is starting to throw up. It's certainly the most exciting time to be working as I do in artificial intelligence. I spent my whole professional life, ever since I was a young boy reading science fiction, dreaming about building intelligent machines. I spent the last 30 or 40 years trying to instantiate those dreams. And it is now becoming part of our reality. Those dreams are turning, it's stopping being science fiction and starting to be science fact. And you can't open a newspaper today without reading multiple stories about how artificial intelligence is taking on new and interesting things in our lives. Now, you can't believe everything you read in the newspapers, of course. And if you added up all that you read about artificial intelligence, you might believe that AI is shortly about to take over. And that's not the case. There's still, it's hard to know, but if you ask experts like myself how much longer it is before machines match humans, they'll say it's 40 or 50 years still in time. Indeed, that explains the title of my book, 2062. That was the average age of the 300 experts I queried around the world when they predicted the machines might match humans. But interestingly, if you'd asked me the same question 10 or 20 years ago, I would have said, again, it was 40 or 50 years time. So we're perhaps very bad at estimating how long it is before machines might match humans in their intelligence. But what's important is we've still got a significant distance to go. And we can only build machines that do narrow tasks today, but they can do useful things. They can translate Mandarin into English as well as any expert. They can read X-rays as accurately and quicker than any doctor. And they can defend against parking tickets as well as a lawyer might do. So there's lots of things that AI is starting to do that will have interesting and useful consequences in our lives. One thing to understand about artificial intelligence today is that it's very data-driven. We do a lot of machine learning that's driven by the data in which it's trained. And that throws up obvious limitations. The algorithms are looking for correlations in data. They're very good at identifying correlations, but not so good at identifying causation. They tend to be rather brittle. We can easily fool them. We can take an image recognition system, we can change a single pixel and turn a banana into a bus, or turn a tortoise into a gun. And they lack our common sense, our empathy, they lack our social intelligence, our emotional intelligence. There's lots of things that they still lack that we have to be careful against. A good example of the sorts of challenges is to pick an area like predictive policing. We have lots of data about where crime takes place. So we can use that perhaps to predict, not in a minority report sort of way. We can't predict exactly when an individual is going to commit a particular crime, but we can say that more crime takes place at these hours in this neighborhood. Maybe we should put more police patrols in that place and at that time. And so if we've got limited resources, that seems a useful prediction to make to try and make our cities safer. But there are some fundamental problems here. By the very nature of data, it's historical. It captures the biases of the past and the biases of the system in which it was captured. Maybe policing in the past was rather racist. We had more police patrols in poorer, blacker neighborhoods. Maybe police officers stopped more black people and therefore arrested more black people. And therefore, we are just perhaps perpetuating the biases of the past if we follow that historical data. And even if we're careful to try and eliminate those biases, there is still a deep fundamental problem, and this applies not just to predictive policing, but to the use of AI in so many other settings, which is we don't actually have ground truth. And it's not clear that we could ever actually collect ground truth. We don't know where crime took place. There's lots of crime that took place that we will never find out about because it's never reported. We only know where crime took place where we apprehended the criminals and prosecuted them. And it's not clear how we would collect that ground truth. We're collecting a proxy for what is the ground truth. Perhaps the poster child that gets mentioned in many of these discussions about challenges of such data-driven approaches is COMPAS, the system that's in use in 20 of the 52 states, used by judges and other officials to help predict which violent offenders will potentially reoffend, and therefore who perhaps should be denied bail, who should not be released back into the community. And there was a well-documented expose of COMPAS, the system, to show that it was somewhat racist in its decision-making. Now, North Point, the developers of COMPAS, were very well aware that this was a problem that the system was likely to run into. And so, rightly so, they had not included race as one of the inputs to the system, because they knew very quickly, otherwise it would inherit those historical biases of the past and would become racist. So race was not one of the inputs, but zip code, postcode was one of the inputs. And as most of you know, in many parts of the United States, zip code is a good proxy for race. And the system was quickly able, perhaps, to learn those proxies. We don't know for sure. This was one of the problems, because the code for a compass is a commercial secret. And despite a court case being brought against North Point, we have still no idea exactly how the code works. But by reverse engineering its decisions, ProPublica were able to show that it was nevertheless somewhat racist. There are many reasons to question the design of such a system. It's based upon a 100-question questionnaire that the defendant has to fill in. Many of those questions in that questionnaire are somewhat dubious. Some of the questions are, what age were you when if you come from a broken home, your parents were divorced, what age were you when your parents separated? How many times have you moved home in the last 12 months? How often, these are genuine questions in the questionnaire, how often do you feel bored? This highlights that problem I was talking about just now, that sometimes we confuse correlation with causation. Maybe it is that boredom is correlated with people who go on to reoffend. Maybe it is that people who move home frequently is correlated with people who go and reoffend. But do we want to prosecute people for moving home too often? That they're merely a victim that their landlord happened to sell their house. But putting aside those concerns, one has to look at the accuracy of the predictions it makes. So it's worth pointing out it wasn't particularly accurate. It was about 2/3 accurate. It got about 2/3 of the predictions right and a third of its predictions wrong. Not actually a particularly accurate performance, but if you look at how the accuracy varies across races between Black people and white people, you can identify some troubling concerns. If you look at the precision, the percentage of people who are predicted to reoffend who actually reoffend, then actually North Point did a very good job. This is actually seems to be what they probably were optimizing for. Precision for Black people and white people was the same, about, as I said, about 2/3. But if you look at the data, if you look at where those errors, those 1/3 errors are falling, they're falling predominantly upon Black people, or to Black people's disadvantage. If you look at the false positive rate, the people who are predicted to reoffend, who don't reoffend, those are the people that you're keeping in jail unnecessarily. There was a much greater false positive rate for Black people than white people. And why is that? Well, there are many different ways of defining fairness. One is asking for the precision to be the same for Black people or white people. Another is to ask for the false positive rate to be the same for Black people or white people. Another is to ask for the false negative rate to be the same for Black people, white people. Indeed, people working in my field have come up with 21 different definitions, mathematically different definitions of fairness. And you can prove mathematically that many of these different definitions are incompatible with each other. If you optimize precision, then you are going to have to accept that the false positive rate is going to be different for the different groups. Unless the two groups are literally identical, or your predictor is 100% right, neither of which is true in this setting, those two fairness criteria are incompatible with each other. If you optimize for one, you will make the other poor. And this is what we are seeing. More generally, we've seen lots of people responding to concerns like this about systems like Compass by proposing ethical frameworks to deal with artificial intelligence, to properties like transparency and fairness and explainability. That's happened at the level of governments. I've worked with the Australian government in their ethical guidelines for companies implementing AI. You've seen it, various tech companies propose ethical frameworks. You've seen NGOs like the OECD, the World Economic Forum, ISO, IEEE, professional bodies like that propose ethical frameworks. There's been a tsunami of different proposals, which I think is disguising the fact that this is like many old technologies that touch our lives. And much of the way it touches our lives, it may introduce fresh challenges because it works at a speed or a scale that we've never seen before. But the ethical challenges are largely the same that we've seen with other technologies. There's nothing particularly magical about AI, with one small exception that I'll come to in a second. But it touches our lives, and we're worried about technology touching our lives in the past. And in particular, in areas like medicine, we have some very well-developed, well-thought-out ideas about ethical frameworks, and those ethical principles that have been applied into a medical setting are entirely adequate, it seems to me, for dealing with the ethical challenges that AI throws up. So, what are the four cornerstones of medical ethics? And they seem to me appropriate ethical cornerstones for any new technology like AI. They're beneficence, do no good; non-maleficence, do no harm, which is subtly different to beneficence. It's worrying about individual harms. Autonomy, that's in the medical sense, worrying about the autonomy of individuals, not respecting people's right to choose, not behaving in deceptive ways. And then the final principle of justice, which brings in issues like fairness and equitability. Again, issues that we come up with that example with Compass. So I said there is one new concern. And there is one new thing that this technology brings that we haven't seen with other previous technologies. And that comes back to autonomy. Previously, in medicine, we think about the autonomy of the individual, respecting their right to choose. But we have now to think about the autonomy of machines. That this is the first technology where machines are given the ability to act largely on their own, and we have to worry about the consequences of those actions. And that's perhaps not surprising why we've seen rich, interesting discussions around autonomous self-driving cars, and as I'll come to in a second, autonomous warfare. But to talk first about autonomous cars, of course, people immediately start talking about the trolley problem. That a self-driving car might come around a corner, there's some pedestrians have stepped into the road. The car has to make a split-second decision. Does it swerve off the road, perhaps killing the occupants of the car? Or does it drive into the pedestrians who've stepped into the road, potentially killing those pedestrians? It has to make that life or death decision. There are a couple of interesting things to remark about the trolley problem, one of which was that it was never proposed to deal with self-driving cars. It was proposed back in the 50s to try and simplify the discussion around abortion, about whether you save the mother and perhaps kill the unborn child, to try and remove some of the heat from those discussions. It does throw up some interesting questions, but from a technical perspective, from a technological perspective, those questions actually are a bit of a red herring. I have friends, colleagues who build self-driving cars, and if you ask them about the trolley problem, you say, what is in your subroutine to deal with the trolley problem? They'll look at you blankly and they'll say, the car does not understand the road well enough for us to branch into a piece of the code to make such a decision. If you look at what the top level loop of a self-driving car is, it's to drive on the open green road. If you've ever seen videos of self-driving cars, they normally paint the open road in front of them green. It's to drive on that green road, and if there isn't green road in front or anywhere that they can turn to brake as hard as they can. That literally is what they will do. There's no determination. The cars don't have a rich enough understanding of the world to be making these life or death decisions. And it's certainly not the case, as people at MIT have proposed with their moral machine, that you can crowdsource people's ideas. There's a website where you can enter your answers to these trolley problems. There's certainly no certainly no hope in trying to crowdsource human ethics as to how a machine should be behaving in this way. And of course, the other area where autonomy is very troubling, and where I've actually spoken to the United Nations, as was mentioned in the introduction, is about autonomous warfare. And that poses very troubling issues, as if we are going to give machines the right to decide who lives and who dies. That will take us to a very difficult place. And also, legally very troubling. It will violate international humanitarian law, a very troubling prospect. And indeed, the whole of this week, a topic that's been in discussion at the United Nations. Hopefully we will see some progress towards regulating the use of AI in warfare. I just want to mention two ethical principles that do get mentioned a lot in these discussions. One that I think is the most overrated principle, which is transparency. For example, if you look at IBM's ethical code for AI, it's the central principle that they have. Now, there's nothing wrong with transparency in most cases. There is sometimes things wrong with transparency. If I'm too transparent, I can open myself for people to hack and to abuse me. So there are some settings where it would be better not to be transparent, but putting those settings aside, transparency is often a useful way of building trust in systems. But it should not be the central principle that you have within your company, within your organization. It is a means to an end. It is not an end in itself. Transparency allows us to see, for example, that fairness is being followed. But there are plentiful settings where you can be transparent. You can be transparent about how you're being completely unfair. That would only heighten the concerns we would have about the system. So transparency in itself is not something that we should desire. Transparency is a means to achieve other ends. And then the other important ethical principle is one of equity. And one thing that's certainly been the case in the last 2 years or so is that the pandemic has only increased some of those inequities that we've been seeing. The pandemic has also hastened the adoption of many digital technologies, and we've certainly seen that has the possibility to only enlarge the inequities we see within our society. And here I think we need to learn from history. This is not the first technological disruption that society's gone through. We've gone through the first industrial revolution when we automated many jobs. And broadly speaking, that has been a good thing. Quality of life has improved greatly. Life expectancy, even in the developed world, has nearly doubled. So it has been a good thing, although there was a significant period of pain. It didn't happen without significant disruption to people's lives. And indeed, the first couple of decades of the Industrial Revolution, many people's standards of lives went backwards. And so we should be very aware of similar risks this time. And it's worth thinking through, how was it that we did ensure, though after those decades of pain, after the Great Strike and the Great Depression, we ensured that everyone shared the benefits of the Industrial Revolution and the quality of all our lives improved. That was by making significant structural changes to our society. We introduced unions to protect the rights of workers, so that Marx was wrong, that the benefits didn't go just to the owners of the means of production. We introduced labor laws to ensure that children weren't put to work and put down the mines. We introduced the welfare state to ensure that people had access to adequate healthcare. We introduced pensions to ensure that people were able to retire when they reached the end of their working lives and they weren't put in the poorhouse. And we introduced significant regulation to protect those rights, to ensure a taxation system that ensured that we were able to afford those things like a welfare system and a pension system. And we're seeing that those that inequality now is starting to increase greatly, and that many of us are starting to be left behind. And we have a real risk, especially as we come out of the pandemic, that that will only be accelerated. And like many people in the tech industry, actually, I will welcome more regulation. We've seen 20 or so years since the invention of the internet and the World Wide Web, remarkable innovations that brought great prosperity and great wealth. But equally, we're seeing some of those systems run to excess. We're seeing a gap opening up between the haves and the have-nots. And indeed, I think that's where many of us are looking towards Europe these days, because Europe is leading the world in many respects in terms of regulating the tech industry in a good way. Despite the naysayers, GDPR has proven to be a useful way, a beginning, not an end, of giving us back certain digital privacies. And we've still to see how it plays out, but the AI Act that's being now worked on, again, is going to extend that into some of the decision-making systems that are increasingly taking part in our lives. So I'm going to end there, but to say that in the long term, I remain very optimistic as to the bounty that technologies like AI is going to bring, even if, as we'll no doubt talk about in the rest of the panel, it's a very bumpy road, and there's a lot we need to do in the short term.
Thank you so much, Toby, for that really enlightening speech and presentation to us. I think we've all got a lot to take away there. I think certainly one of the questions we're seeing already is, how do we reflect this in the law? How do we understand the implications of bias and that discrimination in the law? But we'll come to that question later. I'd like to invite Mark and Eduardo back to the stage, just so we can have a little bit of a reflection time on what you've just been talking about, so that our other panelists and speakers can have a chance to put in their initial thoughts and reflections on what you've just said. I for one, would like to start opening my reflections in terms of, I know we've discussed this a little, and we may even discuss it more later, about transparency. And I think fundamentally, transparency is a means to end, as you've rightly pointed out. But we do often see it in AI ethics principles. Do you think transparency is there trying to stand as a principle, as a standalone principle, or do you think it's just there because of the need to have that transparency, the kind of understanding, the explainability that goes on behind the scenes, whether that's procedurally, process-wise, or decision-wise, for those that are trying to hold it accountable? You mentioned justice as a principle. I know in some quarters justice is also equatable to accountability, but accountability has also been called out as a separate principle in other areas of the world as well. Just thinking about transparency, that's my reflection on what you just said there.
Well, something I didn't talk about, but I think is also important to mention from a technical perspective, is that there are fundamental limits to how transparent possibly we can build systems. We don't know whether we're ever going to be able to explain how a computer vision system sees the world. We don't know how human vision sees the world. And we have actually only a very modest understanding of how human vision works. And there are plentiful ways that we can trick human vision. I mean, there are lots of ways that human vision could be fooled, and there are lots of ways that computer vision could be fooled. And I can imagine that we will never, just like we may never be able to understand all the intricate workings of the human mind. We may never be able to understand how really good computer vision systems see the world. And then we're left with an interesting conundrum. We have a choice. I can build you a computer vision system for your autonomous car that is 99.9999% accurate, never mistakes stop signs and go signs, but I have no understanding of how it works. I just have tested it extensively and robustly, and it is way better than humans and almost never makes a mistake. Or I can build you a system that only works 75% of the time, but I can explain perfectly to you. And I know which car I want to be in.
Indeed, indeed. Well, with that note, I'm going to pass over to Mark or Eduardo. Do either of you have any questions or thoughts or reflections on what Toby's just said to us?
I have one sort of quick question.
Yes.
Sorry, Eduardo, if you want to go ahead, please.
No, first, please.
Okay, so the question I have is kind of to go back to initially you were talking about bias. I was just wondering if it's possible to design a system that even if you could actually make the system, if you could design a system that does not have a bias built in, that's made by people who have biases. Like, is it possible for the designers of these systems to transcend their own bias, or maybe you have counter biases which interact, which allow for bias to be sort of negated? I don't understand if that's possible.
That's Mark, thank you. That's a great question. Yes, it is. And indeed, there's lots of work now where people are working out, if you say, well, there's going to be this racial or gender bias in the system, how we can then change the system or change the output or change the training data to remove that bias. But there are fundamental limits to what you can do. I mean, people often say to me, okay, well, we've identified the system is racist, so let's now eliminate the racism. But there are lots of settings where there is no unbiased answer. So as an example, suppose we're selecting CVs. We're Amazon, we get thousands of CVs sent to us every day. So we build an AI system to scan the CVs and select a few number of people to call for interview. That is a bias. It's a small set out of a big set, which is a bias. Indeed, the old-fashioned name for machine learning is inductive bias. It's finding the right bias to predict, to make predictions on things you haven't yet seen. And we want it to be biased towards the people most worthy of being employed, perhaps the people who are going to do the job best. That's not necessarily the people with the best qualifications. They were the people best at passing exams, but that doesn't mean the necessary best at doing the job. It's a bias one way or the other. Is it the bias that we as a society accept? It's biased towards people, often it's biased towards, in the case of CVs, the people who have done the best at school and university. That's a bias that we've decided is acceptable for selecting people from out of a large pool of candidates for a small number of people to call for interview. Those biases change over time, and they're societal as to what is acceptable. We're not going to employ everyone. We're going to have to decide a small number of people to employ based upon certain characteristics those people have that other people don't.
Eduardo?
Yes. Toby, do you think that, for example, accountability is another type of transparency? Accountability, another type of transparency. Excuse. Now?
No, accountability, I think, is a fair principle. We want people not to hide. So often, you ring someone up and say, something's gone wrong, and they say, I'm afraid I can't fix it. That's the computer. Right? There's a lack of accountability there. And as a computer programmer, I know you could fix those things. That's the people hiding behind the technology. And we don't want people to hide behind the technology. We want people to be accountable, because at the end of the day, machines are not accountable. They're not moral beings. They can't be punished. Only individuals can be held ultimately accountable. Even corporations, we're discovering the limits of holding corporations to be accountable and the challenges of doing that. So, the cornerstone of our most of our legal systems is holding people to account, and we don't want technology to interfere with that. So I'm all for accountability.
Well, fantastic. Thank you all for this first round of quickfire kind of right to reply. I now hand over to our second speaker. So Mark, I'm calling you now to the front stage. And we look forward to hearing from you about IP and the AI and ethics implications of that. Thank you very much. Over to you, Mark. Bye-bye.
Thanks, Patricia. So hi, everybody. Good morning. Let me just call up my slides here. And I'll go to this slide. So hopefully everybody can see it. Yeah, so I'm going to change tax a little bit. I know this is sort of an ethics panel about AI, but one of the sort of things that I, as an IP practitioner, find interesting is this question that is starting to come up more and more now, is whether or not AI systems can be independently considered an inventor or a creator. It's clear that they can create things. It's clear that AI systems can develop, they can help inventors and other people working with technology or trying to solve problems. Clearly, AI can work with them to help them solve the problems, thinking of AI as a tool. But can the AI actually make the shift to a tool maker? So that's kind of where I'm going to be coming from. Much like Toby, I grew up reading and watching a lot of science fiction. So there's a reference to 2001, which is kind of what everybody thinks about when they think about AI. And so that's hopefully we'll never get to homicidal robots or computer systems. The jury's still out on that, maybe in the future. But what I find interesting is predictions about what the future is going to be. And so this is a pretty commonly cited article by Ray Kurzweil about where AI is going to be. He was writing in 2009 about where we're going to do, where AI is going to be in the future, and in terms of what it's going to be able to do and how it's going to be able to reproduce human creativity. I think when he wrote this, people were kind of like, "Oh, this is never going to happen," but we're actually seeing that, and we're dealing with those issues now. So this is just kind of a quick overview of what I'm going to talk about. So I'm going to give some IP considerations about AI and what AI can and can't do. I'm going to talk a little bit about the monkey selfie case, which is the reference to what does a monkey have to do with this, and then sort of the two kind of practical issues that I'm going to talk about, which then lead to a larger consideration as to whether or not AI really should be granted sort of a personhood kind of status. Do we give AI this right, much like we give, say, a corporation in terms of a legal person, a legal personhood status? It's really the issue of, can AI infringe, which kind of leads to the accountability issues that we were talking about before, and whether or not AI can actually be the system that invents stuff. And if an AI independently invents something, is that entitled to be protected through the intellectual property regimes? So just as an example, this was a drug, baricitinib. I always get that wrong, and it's early here in Toronto, so forgive me for mispronouncing that. But this was a drug that was identified by an AI system that could be used in the treatment of coronavirus infections. And so basically what this AI system did was it just combed through a series of known compounds to identify something that it would predict would actually be effective against COVID infections. And it seems, last time I checked, I haven't checked recently, but last time I checked, it seemed to have some utility and actually could be an effective treatment. So, okay, so now we're going to talk about AI and intellectual property. So there's really kind of three main ways that you can protect AI-related technology. One is patents, one is trade secrets, and one is copyright. And so very, very quickly, patents are a monopoly granted from an individual patent office within a jurisdiction. So like the Canadian Patent Office or the US Patent Office or the European Patent Office will grant a patent that says within the geographical bounds of where they have authority, you have the exclusive right to practice whatever that invention is. It's effectively what I would call a negative right. So it's the right to stop people from doing something. It's not the right to actually do it. It doesn't give you permission to do it. And the best example I can think of is pharmaceuticals. So you can get a patent for a pharmaceutical, like that drug for treating COVID infections, but you're not going to be able to practice that invention. You're going to have to get approval to prove that it doesn't kill people and it does what it says it does and things like that. You have to get, that's a separate system of regulatory approval, which then allows for that drug to be made or sold and used in the jurisdiction. So patents don't necessarily grant you the right to do something. They only grant you the right to stop other people from doing it. Trade secrets are a little bit different. Everybody's familiar with the formula for Coke or the Google algorithm for its search engine. You know, those are basically confidential information, and you want to keep that that proprietary information confidential so that you don't disclose it. Or if you do disclose it, it's disclosed with certain conditions. And one of those conditions is that you keep it secret. So if I tell you if I tell you what the formula for Coke is, we would agree that you're not going to disclose it. And it's typically a contractual remedy, although in some jurisdictions there is provisions for trade secret protection, but generally it's a contractual remedy, which means that it's basically a remedy between parties. So the only remedy you would have if there is a inadvertent disclosure or a deliberate disclosure is that you've breached the contract. And so it would be a contract, you would sue the other party for breach of contract. And that limits some of your remedies, whereas patents have a much different set of remedies and abilities to stop other people. And then finally, copyright. Most of this is software related, and in most jurisdictions, software is protected through copyright. So the actual code that Toby was talking about when he was referencing the driverless car, that code is actually protected from copyright. It's actually considered a literary work, and you can see, if for those of you who ever actually looked at computer code, the barrier or the barrier for entry for a literary work is pretty low. It doesn't have to be War and Peace, but software code is basically considered a literary work and it's covered under copyright. So I'd like to make the distinction in an AI system from an IP perspective. There's kind of two aspects that you need to look at. The first is the process, and this is what the AI does. So basically AI, and I'm sure Toby would say this, it's much more sophisticated than this, but they're basically, the way I look at it is they're prediction making machines. And so what you do is you train the AI on certain data to look for certain things. Like, for example, you train the AI to say, look, I want you to identify all the cats in these pictures. You then show them a bunch of pictures of cats, you show them some dogs, you show them some horses, and then the computer learns to distinguish between what's a cat and what's a horse. And so it can eventually develop a way of identifying cats. And that's sort of the process that the AI goes through. And that can be the subject of IP protection, right? So you can have protection for how the AI does that. You know, query whether, you know, if we don't entirely know what the process that it's going through, it makes it a little bit more difficult to get protection for that process. But still, in theory, you could see that we could actually have a protection for the actual process. So think of the process part as how the AI works. Whatever it does, whatever it's doing, that potentially could be protected. Then you have the output, and this is where you're basically taking existing AI systems or maybe a bespoke AI system that you have developed. You're then using this data to make a specific prediction, and that output, that specific prediction, is what is actually protectable. So you can see in the example I gave about the drug identified for COVID infections, that would be the output. So you may be able to say, okay, well, the output of the AI algorithm is actually protectable as something that may fall under one of those three things that I talked about. So it's clear that you should make the distinction between the process and the output, and as a result, you can sort of make, you know, you can understand that there's kind of two aspects that can be dealt with. So with IP, there's really two main aspects, right? One is, as you may recall, I mentioned with patents, you basically have the right to stop other people. So that's done through what's called patent infringement. You're infringing my patent, you have to stop, and then you get a court order to say that you're stopping. I mean, that's basically how it works in most jurisdictions. So when you're incorporating AI technology, you can see that what the AI does, the process could be infringing, and then the actual output could potentially be infringing. For example, if you have the patent for baricitinib, you could say, okay, you can't sell that drug without my permission, essentially. You need my okay to go ahead and do that. And you can see that the AI system is, because it's predicting, it may a lot of times be looking at things that already exist as opposed to predicting a new structure, a new pharmaceutical that could work. So you can, potentially the AI could develop some sort of new drug, but it could also be looking at old drugs, which means there's going to be the issue of patent infringement for the output. There's also patent infringement potential for the process. So what the AI is doing, like if someone has developed an AI system that works really good at, say, as Toby suggested, the visual recognition system or some sort of vision system, if you've developed that, you can then get a patent for that potentially, and you could stop others from using that particular system. And so this raises the issue of if AI has developed and is operating completely on its own, could you sue it for infringement, right? And talking about accountability, a patent infringement case, that is a case of accountability. So are you holding the AI system accountable? Question whether or not we can actually do that. The other issue is ownership. Who owns the IP that gets developed? So for example, if you are the computer programmer, you develop the program, the software for the AI for the process, then that one, that is protectable, but who owns that? And we'll talk a little bit about that. If the AI develops something independently, can that AI system actually be the owner of that invention? And it'll be interesting to see how this plays out. And we're starting to see those cases come up now. And if it can be the owner, can it assign it? If it can't be the owner, can you still have assignment? Like these are the issues, the sort of legal issues that we're sort of starting to deal with now. So just very quickly, this is a little bit old. It's from 2019, but this is a WIPO, which is the World Intellectual Property Organization. This is a sort of grouping of patent families by different entities in the AI space. So you can see that IBM, for example, the leader, that they have about 8,000 patent families. That doesn't mean they have 8,000 patents. There could actually be much more than that. But they're essentially 8,000 separate inventions, or over 8,000 separate inventions that have patent applications filed for them. So this is a number of, you can see a number of companies in a number of countries are pursuing AI protection for a number of different inventions. Now, one of the difficulties with these sort of software patents, which really is what the AI systems are directed to, is they keep coming up with this issue of software is essentially a process. And as a result, patent offices have been wrestling with, not just in the AI space, but in software in general, is you're just really doing an abstract method, or you're just purely doing a mental process. The fact that a computer is doing it does not make it patentable per se. So if you have, for example, a computer doing something that the human brain would normally do, but the computer's just doing it much faster, that's not enough to make it patentable. You generally, in different jurisdictions, and because I'm a Canadian lawyer, my focus is typically on the law in Canada and in the US. I'm not a European attorney, so I can't really comment. I can discuss a little bit about European law to the extent that I know, but I really defer to my European colleagues on that one. But in different jurisdictions have dealt with this in different ways. They define the test slightly different, but I think they're all kind of getting to the same sort of central core, which is there something there, like some sort of technical effect? Is the computer doing something more than just purely doing this mental process, right? If there's some kind of physical element to it, or you're improving the functioning of a computer, that's going to lead to be able to protect it more. But you're really going to be focusing on this sort of technical aspect to move it away from just a purely mental process, because most patent regimes strictly forbid the abstract ideas, like think of like E equals MC squared. You're not going to be able to protect that by itself, because that would be bad for science. You can't stop people from using laws of the fundamental laws of the universe, but you can protect the application of those fundamental laws. And this is really where patent offices are wrestling with it right now. So on the human sort of ownership issue, this is for human-derived inventions. Typically, the classic kind of analysis is creation is the starting point. So, and typically, unless there's a rule or a reason or an employment agreement or some kind of act or legislation, it's really the creator is the owner. You can see if there's an employment agreement and the creator is an employee, then the employer may be the owner of that invention. And the creator may have certain rights, but fundamentally the ownership is transferred to the employer in that situation, at least in North America. And so you can see that when somebody creates something, it then gets transferred to, it could be transferred to somebody else. That person is still the inventor, is still the author, and they get recognition for that, and there's certain rights that go with that. But fundamentally, the ownership could be with somebody else. So what do we do in the case of AI? So if you have a AI-based technology that actually invents something, if they do it in conjunction with human activity, at least there's a connection to a person, and therefore you're actually allowed, well, not allowed, but the ability to say that there's a co-inventor, at least a human co-inventor. There's at least one person there, an actual person who's involved in the inventive process. So there's at least one human inventor. In the case of AI, which is completely independently inventing things, the jury is still out. So who's going to be the owner in that context? So the next issue, just very quickly on the freedom to operate side, is as we mentioned, the process and the output can infringe third-party rights. If you have a scenario where AI technology is incorporated into systems, right? So you're offering goods or services and the AI is used in that. And it is potentially possible that use of AI could actually infringe third-party IP rights. It could actually, the AI itself could be protected. The AI could do something that's protected by third-party IP rights. And it's possible that, depending on how you train it and what you want the AI to do, the AI could independently go out, get some sort of copyrighted work, and in the process of using that copyrighted work, it could reproduce it and therefore be in breach of copyright. So you can see a potential where the AI could be actually infringing either independently or with other people, sort of third-party IP rights. And in that case, who's going to be responsible for it? And some folks have discussed the possibility that there could be some sort of induced or contributory infringement argument, which is basically I have either induced you to infringe. So me personally, my AI system, I've created the system, I've then induced the system to infringe, or I've contributed to that infringement by making the AI do something. And so in a number of jurisdictions, there's this possibility that it's kind of like third-party liability. There could be some some responsibility from the creator or the person who is using the AI, but it raises the issue of, certainly on accountability, and certainly from the issue of we don't really know if we don't really know what the AI is doing, can it really be infringing the system, or sorry, the third-party IP rights? So this is kind of an interesting case. I'm going to quickly skim through it just for the sake of time. This is the famous monkey selfie case. I don't know how many of you have known about it or have been following it. Effectively, to sum it up, this is just a very quick summary, but to even make a quicker summary, a photographer sets up a camera, and apparently this monkey, who's given a name Naruto, he came up, or she came up, and triggered the camera. So the monkey actually took the picture, and it was this picture that the monkey took. So the question is who's the owner of this, and who has copyright in this photo? And PETA was actually arguing that really it's the photographer had nothing to do with it, even though he set up the camera, he created everything, but he never took the picture. The monkey apparently took the picture. And so he doesn't really have copyright. And the question is, who does actually have copyright? And in the US, they found basically that copyright effectively can only be provided to, or can only arise from an actual human creator. A non-human entity like a monkey could not create and be the owner and be the copyright author of the work. And so it raises the issue in the copyright perspective, where basically had jurisdiction in the US saying, a monkey can't own copyright. So can an AI be an inventor? This is just a quick summary of kind of the US, Canada, and the European patent conventions all basically provide, in either the actual legislation or through judicial interpretation of those pieces of legislation, that basically an inventor under a patent act has to be a natural person. It can't be simply some other, something other than a natural person. But until recently, that was never an issue, because only people invented things typically. But now we're having our technology actually, our tools are actually becoming the tool makers. And so we've never had to actually consider that issue. So the typical touchstones of invention in the patent system, they're defined in different ways. In North America, it's you basically have these two components where it's conception or reduction to practice. Conception is you conceived of the invention. Reduction to practice is you actually made it. So once you conceived it, you actually then went out and made it, made the process, made the thing, whatever you're trying to protect. In the European system, and there again, I'm not a European lawyer, so I defer to my European colleagues, but it's effectively this creative act of invention. So you have to basically be making something, and until now, machines weren't making stuff. Until Davis or Davis, I don't know how you pronounce it, but I'm going to say, you say tomato, I say tomato. So Davis is actually this AI system that was created by Stephen Thaler, and he called it his creativity machine. And effectively in 2018, they filed a series of patent applications. This is the little snippet there is from the international patent application, where, as you can see there, it lists Davis, and it clearly says on the cover sheet that this artificial intelligence is the inventor. So no humans have been involved in this. Davis is listed as the inventor. So a number of patent offices now have to deal with this issue. Thaler says that he basically acquired the right to the invention because he's the successor in title. because he's the machine's owner. Anything that the machine makes is he's the owner of it, and therefore he can apply on behalf of the inventor, the AI system, and then the courts have to, the patent offices and the courts basically have to consider whether or not he's actually a proper inventor. So this is what the invention actually, there's a couple of inventions, but this is kind of the best one, I think, in my opinion. So it's basically a container that has this kind of fractal profile. And the idea is that it allows for better grip of the actual container, better storage ability, because you can group them together, you can connect them, so it's less empty space, so it's more efficient. And you actually, because of the design, you have a much greater surface area, which allows for faster heating, faster cooling. Basically, it's the perfect container, and so that's really what this is focusing on. So a bunch of patent offices have looked at it, and effectively, I'm happy to talk more about the specifics of it, but effectively, the European Patent Office, the UK Patent Office, and the US Patent Offices have all looked at this and basically said, no, a non-human can't be an inventor. You basically have to have a human being as part of this inventive process because of the way, and largely what they focus on is because of the previous decisions or the way that the individual acts are structured. You have to have basically an individual has to be the inventor. Now, South Africa they have allowed this patent to go through. It's a little bit technical, but the difference is in the South African situation, there is really no substantive examination of the application. So provided you've met some certain criteria, the patent moves through and will get issued. So there's no kind of substantive review of the process, unlike there is in the European Patent Office, the Canadian Patent Office, and other jurisdictions like the UK and elsewhere. Australia is an interesting case, and I'd love to hear sort of Toby's kind of take on it. Initially, the Australian Patent Office said, no, you can't, this is not permittable, or this is not allowable. But the federal court has now looked at it, and they're going to defer. I'm not an Australian lawyer, and if there are any Australian lawyers, I'd love to hear what their take on this is. But the Australian federal court said having a non-person as an inventor is not incompatible with the patent office, with the patent system, and so that basically it's still, but it deferred it back then to the patent office to say, okay, look at this in more greater detail. So I think I'm running out of time. Just very quickly, in last year, about a year from now, a year past, the USPTO issued 2 reports. These slides, if anybody wants them, I'm happy to provide them. So just send me an email because there are a couple links to the actual reports. They wanted to get people's views about AI-related inventions and what their considerations were and how they saw things. The general consensus was that you don't need to change the IP laws to deal with this. We can, the entire IP system or the patent system is specifically designed to deal with things that have never existed before, inventions and things like that. So the system is flexible enough to deal with this. Question whether or not that's the case. I think if you want to have AI as an inventor, I think you're going to have some kind of legislative change in a number of jurisdictions that specifically allow it. But the consensus was that there is no need to change the IP laws, except to the extent that they may want to offer some kind of new form of data protection, in the sense of presumably how these AI systems work or the data that they use. Or I'm not entirely sure what that new system would be, but they have proposed this idea of some kind of, quote unquote, data protection for AI related inventions. And I think that is it for me. So I'm happy to turn it over to be grilled by my other panelists.
Well done, Mark. That was a really brilliant talk. And I think, ethically, what we want to come out of this conversation is, can AI be an inventor? It throws up those challenges of, can AI create? Humans, we create. Can AI create? It throws up those challenges of accountability. It throws up those challenges of ownership in terms of, could AI ever be a legal person? And I really loved the monkey selfie analogy case. I think that kind of brings it home. But one feels more empathy, perhaps, to use ethical terminology, towards the monkey than perhaps one would to an AI robotic.
Exactly.
You mentioned Davos, and I don't want to kind of encroach too much on our next session coming up. There's two things I want to ask here. One is the interesting thing with the Davos case is, because the AI, nor the original AI inventor who brought the case, the professor, were recognized as the owner of the creation that the AI, in theory, potentially created, could that run the risk of somebody else coming along and recreating what the AI Davos had created and then claim it as their own? Or would it fall foul of the novelty factor and therefore not be registrable as a patent? That was kind of my quick fire first question and observation. But then my second thought, and maybe we can look at this either with Eduardo or with our later speakers on the EU AI regulations, is that the proposed EU AI regulations that have come through do ask for user information in quite a lot of detail, instructions for use, as well as technical documentation. It even goes further for those organisations that need to be under the scrutiny and eye of a notified body, that requires source code potentially to be divulged and disclosed to them, really coming to the heart of that Coke recipe and the Google search engine piece that you raised earlier on. I just wonder, would these kind of factors potentially undermine patent applications? Because while someone is going through the process of approval for high-risk AI systems, they're likely to be concurrently trying to apply for a patent if they haven't already.
Okay, so the first question from a patent perspective is pretty straightforward. So the answer is that once it's disclosed, the novelty, it's no longer novel. So someone else could not file after the publication of these patent applications. So once it's published, it's kind of out there, and it's really whoever got to the patent office first. Now, the issue would be is if somebody, let's say two people, one AI, one not AI, filed relatively concurrently for the same invention, and then it would be a question of who got to the patent office first. But patents are only publicly available 18 months after filing. So you could have this 18-month window where somebody else could file for that, but then they wouldn't. They would have to have had developed it themselves, and they would not be aware of what the AI system in this case did. So once it's published, it's out there in the public domain, and you can't really try to protect it afterwards. You couldn't effectively steal the invention from the AI. So that's the first question. The second question is, I don't think, the one thing I would say about patents, the whole idea of patents is that you want people to disclose things. You don't want them to keep them secret, because one of the things that the bargain that they say with patents is, you disclose to me what your technology is, and I will grant you a 20-year monopoly. So unlike trade secrets, which could be kept secret for forever, if they can be kept secret, that in theory would hold back technology development, because you want people to know what other people are doing, so they go, oh, okay, I see what you're doing there, and now I'm going to add on that, and so gradually human knowledge increases. So the idea is you don't want to keep them as trade secrets, you want to get them out into the public. And part of the whole thing of a patent is you have to disclose how the system works. So whatever you're trying to protect, you have to disclose the best mode typically that you know of doing it. So I think I think in this case, patents could actually be from a accountability, transparency standpoint could actually be more important than trade secrets, because you could actually see how the system is doing whatever it is that's going to do. So one of the problems is, like with the Google search algorithm, is that we don't know how the algorithm works. So everybody's trying to game the system, but they don't really know how it works. And to Toby's point, he raised this earlier on, is that maybe a little bit of secrecy is a good thing, because then people can't hack it. But at the same time, you want to understand how these things are working and arriving at the decisions that they need to arrive at. But if the case is something like the AI has developed a drug, let's say, we don't have to disclose the process that we went through to arrive at that drug. We just have to disclose the drug, right? So the AI it's the same system. It's like Davis doesn't have to disclose how it arrived at the container. It just discloses the container. So I hope that answers your question.
Toby, Eduardo, any questions?
Yeah, just to raise a point of fact, actually, the decision in Australia is being appealed to the higher court, so we don't know what's going to end up. So
yeah, I didn't want to spend too much time going through all the different, but effectively, yeah, we're arguing about it.
Which is, we can put aside the philosophical question of whether AI can invent or create or not, and I actually believe it can. But there's the legal question, which is the patent system exists for a purpose. The purpose is to encourage, incentivize, provide a structure in which people can get returns for their inventions and encouraged to put them in the public domain in the longer term. So, I mean, the question is, if we can get AI to do that, and presumably AIs can do it faster, at greater scale and speed than humans at, is that going to pervert the patenting system?
I don't think so. I don't think it's going to pervert the system, because I mean, the whole idea of the system is to reward development, and we're
but now it will reward the large tech companies who have the biggest AIs, and the lone little inventor is going to be drowned out.
Yeah, but that's always been the sort of dynamic, and particularly in the U.S. The U.S. is very focused on allowing the small sort of inventor who creates something in their garage to protect it and take that out there into the world and make $1 gazillion from their invention. So I think the current system, arguably, whether it's AI or pharma or biotech or whatever, or software, it has tended to favor larger entities, because it's a very complicated process, it's very expensive, and it's only getting more complicated and only getting more expensive. I don't think that AI per se is creating inequities that didn't already exist there. It may aggravate them, and maybe there is a way to compensate that, but the system itself, the patent system itself, I think, is ill-equipped to sort of deal with that kind of those kind of considerations, because it basically it's a system for rewarding invention, and strictly speaking, we're not concerned with how that invention got there or who invented it. It's basically saying, look, we want to get technology out there. So I think it just maintains, it could aggravate this divide, but I don't know if it creates something that wasn't already there.
Yes, Mark, with your experience and where your expertise, do you think that in the future, could you predict if we'll see any kind of legal personality for AI systems? Like companies, for example, a corporation.
Yep. I could. Well, it's not. we have the idea of non-natural legal persons, right? So a corporation, we recognize a corporation as having legal rights. So I don't see that as there is precedent for having non-natural people as legal persons. So I would say I could see that scenario happening. It just it would need we would need to work out a lot of the devil's in the details, and so we need to work out what exactly does that mean. But right now, the way the patent legislation is structured, it typically refers to specifically individuals, and we're going to need some sort of, in particular North America, we're going to need some sort of legislative action to change that, or some sort of judicial consideration that says, okay, it says individual, but an individual can be a non-natural legal person. But corporations, so far, nobody's ever said about corporations being inventors, and but that's never really been an issue, as long as the corporation can be an owner, it can still own it, but people are still inventors. So I'm wary of predictions, because I just know how many times people have been wrong, including myself. So I can see a system, I can see it being addressed in some way.
And with that note, I would like to hand over the stage virtually at this stage to Eduardo for his talk more generally on AI ethics and how it kind of links in with the EU regulations. So thank you very much. Over to you, Eduardo.
Okay, I share my slide. Okay. Well, I first, it's my honor to participate in this conference, and I would like to thank IFCLA and also Barcelona Bar Association for my invitation. Well, in today's presentation, I will like to talk about the importance of privacy regulation focused on transparency, also focus on transparency, also accountability when processing personal data in artificial intelligence systems. Since 2018, we have in Europe a regulation that harmonizes the 27 member states with the fundamental right of data protection, the General Data Protection Regulation, or GDPR. So I would like to explain the importance of the principle of transparency and other measures like data protection from the beginning of the design of AI systems for reinforcing natural person guarantees in the digital era. Artificial intelligence systems mostly depend on personal data processing by interacting with people analyzing their behavior. So that is the raw material of artificial intelligence, and personal data and information produced by natural persons must be protected by enforced legislation. The brand new proposal in April 2021 for a regulation of European Union laying down harmonized rules of artificial intelligence, or named as the Artificial Intelligence Act, established the AI systems rules based on the impact of several risk levels of population. The AI regulation aims a legal framework to be as technology neutral and future-proof as possible, taking into account the fast technological and market development related to AI. In order to provide the needed legal certainty, the proposal contains a detailed list of approaches and techniques for the development of AI to be adapted by the European Commission, in line with the new technological developments. Key participants across the AI value chain are also clearly defined in the proposal, such as providers and users of AI systems that cover both public and private operators to ensure the level of playing field. The regulation follows a risk-based approach, differentiating between uses of AI that create an acceptable risk a high risk, and low or minimal risk. The list of prohibited practices comprises all those AI systems whose use is considered unacceptable as violating fundamental rights like data protection. The prohibitions cover practices that have a significant potential to manipulate persons through subliminal techniques beyond their consciences or exploit vulnerabilities of specific vulnerable groups of such as children or persons with disabilities in order to materially distort their behavior in a manner that is likely to cause them or another person psychological or physical harm. Other manipulative or exploitative practices affecting adults that may be facilitated by AI systems must be covered by the existing data protection that guarantee that natural persons are properly informed and have free choice not to be subject to profiling or other practices that might affect their behavior. The proposal also prohibits AI-based social scoring for general purposes done by public authorities. About this issue, the Article 22 of GDPR related to automated individual decision-making, including profiling, established that the data subject has the right not to be subject to a decision based solely on automated processing, including profiling which produces legal effects concerning him or her or similarly significantly affects him or her. It shall not apply if the decision is authorized by union or member states law, and which also lays down suitable measures to safeguard the data subject rights and freedoms and legitimate interests. It's necessary for entering, in other case, if it's necessary for entering into or performance of a contract between the data subject and a data controller, or it's based on the data subject's explicit consent. In these cases, the data controllers shall implement suitable measures to safeguard the data subject rights and freedoms and legitimate interest, at least the right to obtain human intervention on the part of the controller, to express his or her point of view and to contest the decision. Finally, other prohibited practice comprised is the use of real-time remote biometric identification systems in publicly accessible spaces for the purpose of law enforcement is also prohibited unless certain limited exceptions apply. The proposal also contains specific rules for AI systems that create a high risk to the health and safety or fundamental rights of natural persons like data protection. In line with a risk-based approach, those high-risk AI systems are permitted on the European market subject to compliance with certain mandatory requirements and an ex-ante conformity assessment. The classification of an AI system as high risk is based on the intended purpose of the AI systems, in line with the system product safety legislation. Therefore, the classification as high risk doesn't only depend on the function performed by the AI system, but also on the specific purpose and modalities for which that system is used. There is identified two main categories of high-risk AI systems. AI systems intended to be used as safety component of products that are subject to third-party ex-ante conformity assessment, and other standalone AI systems with mainly fundamental rights implications that will be explicitly listed in the future regulation. This list of high-risk AI systems will be contain a limited number of AI systems whose risks have already materialized or are likely to materialize in the near future. To ensure that the regulation can be adjusted to emerging uses and applications of AI, the Commission could expand the list of high-risk AI systems used within certain predefined areas by applying a set of criteria and risk assessment methodology. Respect to this risk assessment methodology, for high-risk systems, probably the providers and users should also perform a data protection impact assessment, whether personal data is processed. According to the Article 35.3.3 of GDPR, the data protection impact assessment shall in particular be required in the case of a systematic and extensive evaluation of personal aspects relating to natural persons, which is based on automated processing, including profiling, and on which decisions are based that produce legal effect concerning the natural person or significantly affect the natural person, and processing on a large scale of special categories of data or of personal data relating to criminal convictions, and a systematic monitoring of a publicly accessible area on a large scale. The AI proposal also sets out the legal requirements for high-risk AI systems in relation to data and data governance, documentation and recording keeping, transparency, and provision of information to users, human oversight, robustness, accuracy, and security. The precise technical solutions to achieve compliance with those requirements may be provided by standards or by other technical specification, or otherwise the development in accordance with general engineering or scientific knowledge at the discretion of the provider of the AI systems. It places a clear set of horizontal obligations on providers to high-risk AI systems. Proportionate obligations are also placed on users and other participants across the AI value chain, for example, importers, distributors, authorized representatives. AI systems intended to be used as safety components of products that are regulated under the new legislative framework legislation. For example, machinery, toys, medical device will be subject to the same ex-ante and ex-post compliance and enforcement mechanisms of the products of which they are components. The key difference is that the ex-ante and ex-post mechanisms will ensure compliance not only with the requirements established by sectoral legislation, but also with the requirements established by the regulation, without forgetting the data protection regulation. As regards standalone high-risk AI systems, a new compliance and enforcement system will be established. This follows the model through internal control checks by the providers, with the exception of remote biometric identification systems that will be subject to third-party conformity assessment. A comprehensive ex-ante conformity assessment through internal checks, combined with a strong ex-post enforcement, could be effective and reasonable solution for those systems. And assessment through internal checks for the standalone high-risk AI systems will require a full, effective, and properly documented ex-ante compliance with all requirements of the regulation and compliance with robust quality and risk management systems and post-market monitoring. After the provider has performed the relevant conformity assessment, it will be registered those standalone high-risk AI systems in an European Union database that will be managed by the Commission to increase public transparency and oversight and strengthen ex-post supervision by competent authorities. New ex-ante and reassessment of the conformity will be needed in case of substantial modifications to the AI systems, and notably change we go beyond what is predetermined by the provider in its technical documentation and check at the moment of the ex-ante conformity assessment. About transparency obligations, certain AI systems should be taken special account of a specific risk of manipulation they pose. So transparency obligations should be applied for systems that interact with humans, are used to detect emotions or determine association with social categories based on biometric data, or generate or manipulate content, for example, deep fakes. When persons interact with an AI systems, or their emotions or characteristics are recognized through automated means, people should be informed of that circumstances. If An AI system is used to generate or manipulate image, audio, or video content that appreciably resembles authentic content, there should be an obligation to disclose that the content is generated through automated means. Of course, subject to exceptions for legitimate purpose, law enforcement, freedom of expression, etc. This allows person to make informed choice or a step back from a given situation. For that, the regulation also refers to the Personal Data Protection Regulation to treat the transparency of AI systems. Specifically, Article 5 of the GDPR establishes that the principle relating to processing of personal data and says that personal data shall be processed lawfully, fairly, and in a transparent manner in relation to the data subject, lawfulness, fairness, and transparency. Any processing of personal data should be lawful and fair. It should be transparent to natural persons that personal data concerning them are collected, used, consulted, or otherwise processed, and to what extent the personal data are or will be processed. The principle of transparency requires that any information and communication relating to the processing of those personal data be easily accessible and easy to understand, and that clear and plain language be used. That principle concerns in particular information to the data subject on the identity of the controller and the purpose of the processing, and further information to ensure fair and transparent processing in respect to the natural person concerned, and the right to obtain confirmation and communication of personal data concerning them which are being processed. Natural persons should be made aware of risk, rules, safeguards, and rights in relation to the processing of personal data, and how to exercise their rights in relation to such processing. In particular, the specific purpose of which personal data are processed should be explicit and legitimate and determined at the time of the collection of the personal data. The personal data should be adequate, relevant, and limited to what is necessary for a purpose for which they are processed. This requires, in particular, ensuring that the period of which the personal data are stored is limited to a strict minimum. According to those principles, personal data should be processed only if the purpose of the processing could not reasonably be fulfilled by other means. In order to ensure that personal data are not kept longer than necessary, time limits should be established by the controller for erasure or for a periodic review. Every reasonable step should be taken to ensure that personal data which are inaccurate are rectified or deleted. About the governance of AI systems, ex-post enforcement should be ensured that once the AI system has been put on the market, public authorities have the powers and resources to intervene in case AI systems generate unexpected risk, which warrant rapid action. They will also monitor compliance of operators with their relevant obligations under regulation. The proposal doesn't foresee the automatic creation of any additional body or authorities at member state level. Member states may therefore existing sectoral authorities, for example, data protection authorities, who will be entrusted also with the powers to monitor and enforce the provision of the regulation. All this is without prejudice to the existing systems and allocation of power of ex ante and ex post enforcement of obligations regarding fundamental rights in the member states, like data protection and privacy. When necessary for their mandate, existing supervision and enforcement authorities will also have the power to request and access any documentation maintained following this regulation, and where needed, request market surveillance authorities to organize testing of the high-risk AI system through technical means. In this case, AI systems should be built based on principles of data protection by design and by default according to the Article 25 of GDPR. The AI providers must be taking into account the state of the art, the cost implementation, and the nature, scope, context, and purposes of processing, as well are the risk of varying likelihood and severity of rights and freedoms of natural persons posed by the processing both at the time of the determination of the means for processing, ex ante, and at the time of processing itself, ex post, to implement appropriate technical and organizational measures, such as pseudonymization, which are designed to implement data protection principles, such as data minimization, in an effective manner that to integrate the necessary safeguards into the processing in order to meet the requirements of GDPR. So that the AI providers have to implement appropriate technical and organizational measures for ensuring that by default, only personal data which are necessary for each specific purpose of the processing are processed. That obligation applies to the amount of personal data collected, the extent of their processing, the period of their storage, and their accessibility. In particular, such measures have to ensure that by default personal data are not made accessible without the individual's intervention to an indefinite number of natural persons. Finally, in order to be able to demonstrate the compliance with this regulation, the controllers should adopt internal policies and implement measures which meet, in particular, the principles of data protection by design and data protection by default. Such measures could consist inter alia of minimizing the processing of personal data, pseudonymizing personal data as soon as possible, transparency with regard to the functions and processing of personal data, enabling the data subject to monitor the data processing, enabling the controller to create and improve security features. So that and certification mechanisms could be used to demonstrate compliance with the requirements set up. The proposal of AI regulation also creates a framework for the creation of codes of conduct, which aim to encourage providers of AI systems to apply voluntarily the mandatory requirements for high-risk systems. Those codes may also include voluntary commitments related, for example, to accessibility for persons with disability, stakeholders' participation in the design and development of AI systems, and diversity of development teams. The protection of the rights and freedom of natural persons with regard to the processing of personal data in the AI system will require that appropriate technical and organizational measures be taken to ensure that the requirements of GDPR. Finally, when developing, designing, selecting, and using applications, services, and products with AI component that needs the processing of personal data or to process personal data to fulfill their task. Producers of the products, services, and applications should be encouraged to take into account the right to data protection when developing and designing such products, services, and applications, and with due regard to the state of the art to make sure that controllers and processors are able to fulfill the data protection obligation. Therefore, applying the principles of transparency and the privacy by design and by default are one of the first steps to protect the right of users in the AI systems. Thank you all for your attention.
Thank you so much, Eduardo. And I'm going to invite the other speakers back up to our virtual stage this morning. I think it's a really useful reminder to think that transparency is not new. This is an ethical legal principle that we've seen in GDPR, and we're seeing again in the proposed AI Act. I think it's really also been very useful for us to reflect on accountability that we see through compliance, risk management, and quality management systems raised through the new proposed EU AI Act. Furthermore, I think it's really interesting that you've brought kind of personal data and GDPR into reflection, because this has a big bearing on bias and how AI systems can be and often are biased. And to an earlier point today, can our AI systems ever be unbiased, or can that bias just simply be mitigated? And we hope for the best with the outcomes. And I think perhaps something that isn't as wholly clear in the EU AI regs in terms of ethical principles, but I think it is undergirded in it through what we saw with the work of the EU AI high-level expert group, is fairness. And to Toby's point earlier today, there are 21 mathematical different versions and equations for understanding what fairness looks like mathematically. But in terms of what does fairness look like from a legal perspective, depends on the measure of the law that you're applying to it, and the sector and the context and its application domain of the AI. So we've got lots to be thinking about and learning from an AI and ethics perspective. So they were just some of my reflections, not so much questions, but I'm open to Toby and Mark. Do you have any questions there for Eduardo before we open up to the wider audience?
Yeah, one thing I raised, I think actually one of the most interesting new parts of the AI Act are the red lines that it's starting to draw in terms of real-time use of biometrics. And am I right in thinking there was something about subliminal methods as well in there? So I'm interested to know how those are likely to evolve or change, or whether the Act is allowing that list to grow, or as technology matures.
Well, we have to keep in mind that GDPR is a partial regulation, is only to protect personal data. Of course, there are a lot of regulation about other topics, for example, trade, secret trades, for example, that when you exercise these rights, for example, my right to know which is the process behind the algorithms, we have to know if this information is not affect or is violating another right of the owner of this technology. It is a balance. It's not easy to respond this, Toby, because it's the mechanism or the process we have to use depends of each type of technology of AI systems. This is the reason that the European legislation use the risk assessment for not only AI's Act legislation, also for data protection regulation. This is the principle for everything, for analyzing everything.
Just very quickly, I just have a quick question. Does this, or maybe you could talk a little bit about sort of what are the remedies that would be if there's a breach of, or does it create new remedies? Is there something that like, as a non-privacy lawyer, I'd like to know kind of what recourse do people have if there's a breach?
Well, it's difficult, Mark.
Okay.
Well, remedies. These regulations, in principle, the GDPR is a special regulation because it's is focused to risk, to manage risk. It's like a standard, international standard, like ISO. It's similar. Each company or each owner of this technology has the responsibility to analyze the assessment, to make this assessment about the high risk technology is used, and also if this high risk affect data protection or freedom of speech on another person, for example, because when we talk about fundamental rights, is every fundamental rights established in conventions, international conventions, or European charters. It's complicated because also the level of complicating about the ethics. So principles always changing, and I think the accountability is the fundamental tool to develop a secure and respectful AI systems with the fundamental rights.
Thanks very much. I'm now going to open up some of the questions from the audience. It is one that came a bit earlier doors with regard to something Toby had mentioned regarding bias and the inherent racism, certainly that was held in that compass system that we heard about for the recidivism tool that it applies across 20 states of the United States of America. this particular question focuses more probably on not so much about the kind of bias and the bias that the system ultimately had, but would it be lawful, would it be fair for the developer who created the system, or one of the developers who may have created and designed the system, to be liable for the AI if the AI were ultimately to be found out to be biased? I think that's hopefully that gives due respect to that question, but thought I'd share that with you, because there are a number of initiatives, I think, around the globe. I mean, American Computer Society, here in the UK, we've got the British Computer Society, who are calling out for a professional code of conduct for developers and potentially designers, actually, as well, with regards to AI. I'm personally of the view, I'm not so sure that they actually have as much control over the outcomes of the system as people would like to ascribe to them, unlike accountants, solicitors, and other third-party auditors, perhaps, who come in and have their own professional codes of conduct, and they can remain and retain an element of independence. I'm not so sure that AI developers can in quite the same way. What are your thoughts, Toby?
Yeah, no, I think you're right to say that AI developers can't alone be held accountable here, because, well, first of all, they work in big teams, and so there's a bit of distributed responsibility. And then a really important thing, which is very unique to this technology, which is that a lot of this is driven by machine learning. It's trained on data, and the developer may never have seen that data. That may be someone else's job, as to, finding the data and training the system. So they can't be held responsible for that. And then frequently, and this is even more challenging, we see systems being fielded live, trained on incoming data, because the system is live out there responding over time. And then, who then is responsible? There was the wonderful example of the Tay chatbot, which was left live, receiving tweets from the internet, and became this racist, misogynist, Hitler-loving chatbot, which was a reflection of the tweets that the public had sent it, not of any of the data it was trained on. So there is the real challenges as to work out who is going to be held accountable then, because there are so many people, and it's such a responsive thing to the data as much as to the program. People don't realize we don't program computers to do what they do. They're learning in many respects what they do.
No, absolutely agree there. Absolutely agree. This one seems to be a much more IP question, and I'm not sure I'm going to be able to do it justice, but Mark, I'm going to level this one your way. It's saying on an international level, as well as the AIPPI and WIPO are presently evaluating IP protection issues related to AI. What are your thoughts now? In actual fact, I'm going to add to that. In the UK, we've just had our national AI strategy implemented last Wednesday, or out to consultation last Wednesday. And in there is a promise of a launch of a consultation to consult on copyright and patents for AI through the international, the IPO office here, intellectual property office here in the UK, to kind of really address some of these challenges we talked about earlier around DABUS. What are your thoughts about that? Do you think it's going to go anywhere? I suppose it's that question again of how much do you want to predict the future?
No, I think everybody is struggling with these issues, and sort of how do we deal with these really novel kind of. It's on the one hand, it's a very simple question. Can an AI be an inventor? Can it be a creator? On the other hand, it's really, really complicated, because particularly in the context of IP, intellectual property is limited by jurisdiction. So, for example, the US has its own system, Canada has its own system, the European system, and they're all, you can't sort of, create one size fits all, right? Like everybody's going to have their own kind of view. So WIPO can make its statements, unless there's some kind of international treaty that all companies are going to, there is a movement, and it's been going on for a number of years, as harmonization, so that every IP system is relatively the same, and is looking at the same criteria. So unless there is some kind of, I could see some kind of AI inventor international treaty, which then countries are going to be a signatory to, which then says, okay, within X number of years of becoming a signatory to this agreement, you're going to conform your patent act or your copyright act or whatever to the international standard that we have agreed to. So I can see that something like that coming about. But certainly we're in the very early stages of that. I'm not familiar with any kind of movement to, like, there certainly is no draft treaty that would deal with that as far as I know. But I think that's going to be the problem that complicates it all, is that you're dealing with 190 countries that have their own views on what this is going to be. And even now, like, you can see the difference between, the South African Patent Office and other jurisdictions. There's a number of jurisdictions that just kind of allow stuff to go through without having sort of a substantive examination of things. And so it's a I know this is a common phrase, but it's a patchwork of legislation that's going to have to be addressed in each of those scenarios. So I could see one jurisdiction, if they wanted to be very forward thinking, they could suddenly say, okay, well, we're going to recognize AI as an inventor, so all of the people are going to now file in our country and use our patent system. So I could see that, it's sort of being gamed that way, but it's difficult because of the international characteristic of IP.
And I think you've touched upon something very valid there. Data is without borders. The technology is without borders. Digital is without borders. We might like to put some data protectionism, data sovereignty, digital sovereignty, some of this language we hear in some of our policies across the globe. But fundamentally, we're going to need a greater level of international cooperation and collaboration. We're seeing some greater collaboration there between the US and EU. There may well even be some between the US and UK. We've seen some collaboration on kind of armed warfare very recently, or warfare between the UK and Germany, and also the UK, the US and Australia. Forgiveness out to our French friends there. Don't want to get too political, but fundamentally we've got across the globe about 160 different types of ethical principles, frameworks and guidelines going off. The OECD has been great at creating an AI ethics policy repository and observatory for this. The challenge I kind of think about, and we've talked a lot about accountability today, and I think that comes to the heart and the nub of, can AI create? Is AI an inventor? To some of why the EU AI Act has even come into proposition here and being proposed, is these ethical principles that organisations and governments across the globe have tried to implement, fundamentally don't have teeth unless you can actually have them enforceable. And self-regulation aside, and kind of honourable codes of conduct and codes of principles and the likes, unless there's a kind of a law that makes them enforceable, how can we ever have held people to account? So I think this EU AI regulation, this AI Act, is a brave and honourable move on the part of the EU. It may not be perfect. There are answers that we still need, or questions that we still need answers to, like, can AI ever be granted a legal personhood? How far does the subliminal learning or the subliminal messaging and the manipulation, the exploitation go to be high risk? We've looked into some of the transparency requirements of things that perhaps aren't even in the high risk bracket. They are the acceptable risk bracket, with the chatbots and the fake and deep fakes and the artifacts there as well. So I suppose my last question to everyone in the 2 minutes we've got to go is, and I think this will be a quick fire for everyone, should a human always remain accountable? I think everyone in this room has that question at the heart with AI ethics. Should a human always remain accountable? Eduardo, over to you.
I hope no. I prefer to respect the other fundamental right, is the dignity of a human being, no? Our space to be free, to be free to think and to do that I want to do without any kind of accountability.
So that humans should be accountable for the outputs of AI, or humans should not be accountable for the outputs of AI?
No.
Okay, right. Mark, over to you. Should humans always be accountable for the outputs of AI?
I'm hesitant to say that they always should be accountable, because it's really, certainly about, from a legal perspective, very broadly, you're accountable for the things that you're responsible for, either directly or indirectly. And the issue, I think, for AI is that, and Toby mentioned this, a lot of times, the AI is doing its own thing and we don't know what it's doing. And should a person be responsible for that? And I'm sure that the argument of, well, someone is acting as my agent. If I don't specifically tell them something, they're still my agent, and therefore I'm still responsible for their activity. I could see it going both ways, but if I have no idea what the AI is doing and it goes off and infringes somebody else's patents, question whether we would know that it's infringing, because nobody knows what it's doing. But if we could figure that out, am I going to be responsible for that? I would have a hard time arguing yes, but I can see arguments. Typical lawyer answer is it depends. So yeah, I'm torn. Can't say one way or the other.
And last but not least, Toby, our leading light and authority on all things AI and ethical for this conversation today. Should humans always remain accountable for the outputs of AI?
Well, I don't think corporate liabilities work very well, so I'd be very reluctant to introduce a new actor, an AI, that we give liability to. And certainly from a technical, moral perspective, I don't think AIs can be held accountable like humans can. So I would be reluctant to let them be held accountable for anything.
Brilliant. Well, thank you very much for all our speakers today. I am reminding everyone that we are now going to a 30-minute break. So thank you to ICAB for hosting us, for keeping all things technical going right now. Thank you, Mark, Eduardo, and Toby. And I'm sure all our audience would share with me. I'd like to give you a round of applause virtually. Thank you so much for all your hard efforts in coming together today. And I look forward to speaking to you all at some point again soon. Thank you to all our audience. Enjoy your 30-minute break and look forward to the rest of today's IFCLA conference. Thank you. Have a good day. Bye-bye.
Thanks, everybody. Bye.